just not between the flags.
All right. Well, that's okay. I think that's all right. It's just kind of weird to. Okay. I think in interest of time, we're going to ask everybody to get to their seats and get started. All right. We're just going to get started in 1 minute. We're going to let Mark find his seat and then start the meeting. And just to know, my co-chair is actually, Senator Flexer is actually joined online. So just wanted to make that announcement, but I think we'll just call the meeting to order, ask folks to go around and introduce themselves first in the legislative office building room, and then we'll move to the folks on Zoom. So I will start with Karen Foley O'Connor.
Good afternoon, Karen Foley O'Connor, CEO of the Network Against Domestic Abuse, providing services to North Central Connecticut.
Great. Mark, we're going to give you some time, so I'll come back to you last.
Nancy Tyler, attorney in Hartford, Connecticut, and survivor representative.
Eulalia Garcia, District Administrator, Department of Correction.
Good afternoon, Andrea O'Connor. I am the Family Violence Victim Advocate Program Manager for the Umbrella Center. I supervise the court-based advocates in Milford, New Haven, and Derby.
Good afternoon, Gail Petaway Hardy, and I'm an Executive Assistant State's Attorney at the Chief State's Attorney's Office, and I'm the Chief's Designee.
All right, and Mark.
Good afternoon, everyone. I'm Mark Pelka. I work at the Judicial Branch Office of Victim Services as a Deputy Director, and happy to be here today. Thank you.
Great. And I am Megan Scanlon, the CEO of the Connecticut Coalition Against Domestic Violence. I will turn it over to the folks on Zoom. If you can just unmute yourself and announce your name and the organization you're affiliated with.
Captain Ryan Maynard, Commanding Officer of the State Police Training Academy.
Captain Heather LaRock with the Windsor Police Department.
CJ Four-Shooter, Regional Manager for Judicial for CSSD. Afternoon, everybody.
I think there's more online than 3. I think we counted 10, so.
Hi, everyone. I can introduce myself. I'm here presenting today. My name is Darren Mitchell with the National Council of Juvenile and Family Court Judges.
Thank you. So, okay, great. Okay. And I did announce that Senator Flexer's online. I know, just to know on the record, the Senate is actually in session as well. So she'll be in and out of this meeting as required by her other duties as a senator. So moving on to the next agenda item is the approval of the May 29th meeting minutes. Is there a motion to approve?
Motion to approve.
I heard CJ, motion to approve.
Second.
Second.
All right. Any discussion? Okay, hearing none. All in favor?
Aye.
Aye. Aye.
All right, moving right along. Subcommittee reports. First up is law enforcement model policy. I will just note you may or may not have an update this meeting, which is fine, but just want to note it for the record. All right, hearing none, we'll move on to the next subcommittee, arrest warrants and orders of protection, compliance enforcement, and outcomes.
Again, good afternoon. The Arrest Warrants and Order of Protection Subcommittee met virtually on June 18th, 2024. We began a discussion of firearm seizure and surrender and orders of compliance. Chief Rosado, Captain LaRock, and Captain Maynard from the state police were able to share their procedures and experiences in firearm seizure and surrender. They also discussed the differences used depending upon whether or not an arrest will follow versus no arrest. We decided as a group that we would invite Brianna Maurice, who is a sergeant with Connecticut State Police, Special Licensing and Firearms Unit, to come speak to us at a future meeting. Several members of the group indicated that I believe back in 2020, she had addressed a group, and it would probably be beneficial to hear from her again. We also discuss what happens to cases when a person who is the subject of an order not to possess firearms picks up a new charge that's unrelated to the DV case. As we all know, or as many of us know, all of our courts have a Part A and a Part B, and most often our DV cases are Part B cases. Some courts also have gun dockets, some courts have DV dockets, and we realize that different courts handle this situation differently depending upon the seriousness of the new offense. We discuss whether or not there's a way that we can sort of discuss ensuring some sort of consistency across the state. I believe that was all that we discussed during that meeting. Our next meeting will be held July
17th, right? It was a Wednesday.
July 17th at 11 a.m. That's all I have to report.
Any questions, comments? Okay. All right. Moving on to offender intervention standards. All right, nothing to report there. So we'll move right into, I know everybody's excited to hear from our presenter today. Darren Mitchell from the National Council of Juvenile and Family Court Judges. He'll be going over orders of protection, firearm monitoring and compliance, and the best practices. And just to give folks background, this really came out of the fact that we in Connecticut are obviously have a very strong policies around firearms, but really looking at ways in which other states have enacted best practices that we might be able to look at and adopt here. And just think forward thinking, we do have, this committee has a report that has to be presented at our December meeting and then issued to the legislature. So certainly this discussion and presentation today will help inform some of those recommendations that we'll put together over the fall and the winter. So with that, I'll turn it over to Darren, who I know is on Zoom.
Right. Yes, thank you so much, Ms. Scanlon. And thank you all for having me. I'm really delighted to be here with you virtually. Some of you I see are in person. I'm sure there are others who are listening virtually. And I absolutely plan to share with you some of what we've learned over the years in working with communities all over the country on this issue of how to best address access to firearms by people who have caused harm in intimate partner relationships. So my name is Darren Mitchell. I am a fellow with the National Council of Juvenile and Family Court Judges, or NCJ-FCJ. We are a national judicial membership organization, largest in the country, and I am part of a team. I previously worked with them as a consultant, and I've joined them as a part-time employee over the last year and a half or so. But we, as a group, have been working on issues related to firearms and domestic violence really since it became federal law under the initial Violence Against Women Act, that folks who were subject to certain orders of protection could not have access to guns. And over that, those many, many years, we have been training and offering technical assistance, including intensive technical assistance to communities around the country who have tried to improve what they're doing around this issue, statewide, local, regional, in pretty much every format you can imagine. I've been doing this work since 2000, so I'm coming up on my 25th year of trying to help us all do a better job around making sure that people who have caused harm don't ultimately kill their partners, and many others, as we'll talk about. I'm an attorney, and I am bringing to you our lessons learned, ideas, and experiences from working in other places. I'm going to share with you a bunch of ideas and a bunch of practices that are out there, and also how we think about this issue, both in civil or protection cases and in criminal settings as well, to give you a sense of how we come in and take a look at what folks are doing and how to potentially enhance the response. So that's the background. I'm going to share my screen with you here. And can I get a thumbs up that you all can see it?
Yes, we
Awesome.
can.
Thank you. Appreciate it. All right. So opportunities, really, I'm going to be talking about a lot of opportunities. And I'm not an expert on Connecticut law. I know something about your law. I've had some conversations with folks in Connecticut. It's not my first time talking about this issue in Connecticut over the last decade or so. But you all are the experts on your law and implementation. So I'm really here to share ideas from elsewhere and help you think about how they potentially can be tailored to your response in Connecticut. And I'm going to start, one of the things that I learned from someone who works on addressing public health challenges generally, and I consider this, and I think most of us consider this to be a public health, public safety, public health challenge, is you don't want to scare people. You want to have people be concerned and then give them hope. So concern and hope is really the formula for making progress on these kinds of sometimes intractable problems. And so that's what I'm going to try to do with you today. The concern, I'm not going to dwell on because I know many of you have expertise in this area, know this stuff already, but I want to make sure we're on the same page around the problem. And then, so that's the concern. The hope, I'll be talking about practices that seem to be making a difference. So as I'm sure virtually everyone knows, that access to a firearm by a person who has committed intimate partner violence is one of the greatest factors indicating that there will be a domestic violence homicide. And this stems back to research that was done by Jackie Campbell of Johns Hopkins University School of Nursing, a meta-study that she did in the early 2000s, where it, above all the other factors, strangulation, stalking, sexual violence, on all the other things, it was pretty much the highest risk factor present. And some earlier research shows that if the offender is an intimate partner of the victim, the homicide risk is increased by 8-fold just by having a gun in a home in that particular study. And it goes up 20 times if there's actually a history of domestic violence in the home previously. And there's more. There have been more studies since then, and pretty much guns have risen to the top as important risk factors to be addressing. And here's some more information around that. The firearms are the weapon of choice for domestic violence homicide, especially femicide, men killing women. And generally speaking, it is around 2/3 of intimate partner homicide cases where a woman was killed, firearm was used to commit the crime. That's varied a little bit. And in most instances, most places, the vast majority of instances, mass majority of places, guns are used more than all other weapons combined. For you in Connecticut, it's a little different, in part because, although some of you may feel differently, the gun culture and the access to guns in Connecticut isn't what it is in some other states. We never want to forget, though, that firearms are not only the means of causing death, they're also the means of causing a continuing course of what some people have called domestic terrorism in the home, or coercive control, the domination, the isolation, and the microregulation of your partner's life and creating a climate of fear. So not surprisingly, research has shown that guns are really effective weapons or tools in continuing a course of coercive control in intimate partner relationships. And Susan Sorensen's research out of the University of Pennsylvania has illuminated that for us all. We also know about the connection to community violence risk and mass violence risk, between that and intimate partner violence. And so research has shown that in this particular study that more than 2/3 of mass shootings, 4 or more people killed, not including the perpetrator, the shooter was either had been adjudicated an intimate partner abuser and had a history of domestic violence, or the shooting itself involved the death of an intimate partner or the attempted murder of an intimate partner. And so there's a close connection. I'm sure many of you have heard that before. When we're addressing intimate partner violence and guns, we're also hopefully creating community safety as well. And of course, law enforcement officers face extreme danger in domestic violence calls. And the vast majority of law enforcement officers who are killed in response to domestic violence calls, it was guns. It was a gun that was used to commit the murder. And some more research from the Fallen Law Enforcement Officer or the National Law Enforcement Officer Memorial Fund. More officers were shot responding to DV to any other crime. And in addition to that, you can see some of the data from 88 to 2016, kind of startling that more officers were killed responding to domestic violence than to drug-related arrests. So first responders need to be concerned about this too. And in fact, people who have caused intimate partner harm present a constellation of risks to themselves. Suicide is certainly part of this. And there's more and more research. In fact, I heard some research studies just a couple of weeks ago around the connection between intimate partner violence and suicide, murder-suicide, but also suicide of the perpetrator. But you can see this constellation of risk, officer-involved shootings, community violence, the mass shooting piece I already told you about. Armed domestic violence perpetrators or abusers are behind many of these forms of firearms-related violence. Bringing it home to you in Connecticut, it's a reminder for those of you who already know, maybe new information for some of you. In the Connecticut Family Violence Homicide Report of 2022, looking at 87 to 2022, you can see that firearms, like most places, were the weapon of choice for domestic violence homicides in Connecticut. Again, I mentioned earlier, it's not 2/3 of the cases, but it's the majority of cases. And as you all know, in response, Connecticut has some laws. And Ms. Scanlon alluded to the fact that you have some laws and some practices that are in many instances state of the art. But I just want to remind you, again, I'm not going to teach you about Connecticut law, but just to remind you what you have as legal authority, which puts you ahead of many of the places where I do my work, where there's little authority or little explicit authority around firearms. That's changing, but it's true in many parts of the country. Your officers can seize firearms at the scene of domestic violence offenses under certain circumstances where the gun is in the possession of the person or in plain view. So it's not a license to search, but it is the grounds to take guns in certain instances and then maybe pursue a search warrant in other circumstances. And the gun has to be returned, of course. It's a temporary taking unless there's a reason that the person is not allowed to get the gun back. This is kind of a safekeeping provision. We all know one of the things I didn't mention is separation violence, and the clear research finding that after a person takes steps to separate themselves from the person who's causing them harm, and some research shows around a 90-day to a year-long period where this could be the case, there are elevated risk of harm despite the separation or because of the separation even. And so this temporary safekeeping kind of provision, even if the person is not otherwise prohibited from having a firearm, can be life-saving. You have prohibitions based on convictions, misdemeanor family violence crimes. It's recent, very recent. So it's only a crime that's been committed since October of 2023 of last year. This puts you pretty much consistent with the federal misdemeanor crime and domestic violence prohibition under the Federal Gun Control Act, the so-called Lautenberg Amendment. And in fact, your violent misdemeanor law goes further. It doesn't only cover intimate partner misdemeanors. Of course, protective or restraining orders, orders of protection, are a basis under Connecticut law to restrict the person's access to firearms. And the language is here. There's language around the attempted use or threatened use of physical force. And it includes orders from other states. And importantly, it includes ex parte orders. As long as there's been as long as there's been notice to the person who is being restricted. And so this puts you ahead of the federal law and catches Connecticut up to the growing number of states that have prohibitions based on ex parte orders. Again, separation violence, this is a key safety provision provided it's implemented. Finally, as part of this restraint against access or possession, there's actually a surrender/sale requirement. And this is wonderful. Not all states have this, but within 24 hours, actually it's immediately or within 24 hours, at least within 24 hours, the respondent has to actually get the gun to law enforcement or sell it to a federally licensed dealer. There's opportunities to get the gun to go to someone else who's eligible down the road, but as an immediate safety provision, that 24 hours, that gun must be turned in. And of course, this is going to require a protocol. It sounds like there's been a discussion in one of the subcommittees around some of these issues, and what the protocol and what things look like for law enforcement and for folks who are trying to turn in their guns. And certainly, if you have questions about that or want to discuss it, I'm happy to do that. And I should say that we provide technical assistance on this issue nationally. And if you have follow-up questions, you want to have a conversation, whatever that looks like, please reach out and we can help. I'm going to move on. The other thing I should say, it's hard in this virtual and in-person circumstance, but if someone wants to speak up, wants to raise their hand, or if you have access to chat and ask a question or make an observation, I certainly welcome it. Now we're turning to these suggestions we have based on our experience working around the country. And one of the things I want to say quickly at the beginning is that one of the big lessons learned is that there's certain keys or ingredients to success. You need leadership, and you're already taking leadership in the state of Connecticut. This committee is taking leadership. Its subcommittee is clearly taking leadership. And those of you who are giving your time to this work in this way are exercising leadership. On a local level, that leadership can be chief of police, but it doesn't have to be. It can be a presiding judge or another judicial officer, but it doesn't have to be. It can be a prosecutor. It can come from any one of the important stakeholders, but having a strong leader who's willing to galvanize people and get things going, we have found has been really important. Engaging the community, identifying community needs, understanding why some people aren't calling on law enforcement. What's the mistrust based on? And we know a lot of the reasons for that, but to have those conversations, what do you need for safety as a survivor of domestic violence, including historically underserved or marginalized communities within Connecticut, bringing them into these conversations, the nexus between this and community violence that many are facing. To have those conversations is key. And then, of course, collaboration. No one can do this alone. We've worked with many folks who wanted to get something done, including presiding judges, but weren't able to until they really got everyone on board and buy-in. And so you already have, this is a multidisciplinary group here I'm talking to, you already have the basis for strong community collaboration. I can see it statewide, hopefully locally too. Those of you who have coordinated community response teams or other multidisciplinary groups that meet. Maybe you have a domestic violence high-risk team, or you've come together around LAP, the lethality assessment program. That collaboration is absolutely key to make this stuff work. So I told you I would share a little bit about how we approach these issues. And one of the things that we do is map. We do a lot of mapping with folks. When we come into a community and are trying to help them figure out what are our opportunities to improve our processes, we sit down and we map their processes, and we get a big multidisciplinary group to do that and to identify opportunities, gaps, and challenges, and to come together around what work needs to be done. So I cannot overemphasize the effectiveness of getting groups of folks with different perspectives from different agencies and different approaches, including all the important stakeholders, around a table to map out your process and generate some kind of shared understanding about what it looks like, and then around where your opportunities to improve are. If you're interested in doing this mapping, whether it's statewide, your processes, or local, please reach out. We can assist. We have a process. We have a way to do it that's been that we've done probably in 25 communities now, that really works well. It's always successful. I've never had it not work, not yield hopeful results for the group moving forward in planning. So when we map and when we understand what this all looks like, this is focused on firearm surrender, which you have in Connecticut. And I understand that part of what you're thinking about is how to make that work, how to implement these laws. So this is one way that we think about this. We think about opportunities at a number of different kind of critical junctures. Or, you know, to borrow language from another way of looking at what courts and others can do in these difficult problems, intercepts. At what points do professionals have an opportunity to learn about access to a gun and potentially do something about that? And when you look across a order for protection process, here's what stands out in our work. First, we call information gathering. And that's about, first of all, ensuring that survivors who are considering what they want to do, whether they want to do something, do they want to become court involved through a protection order? What do they want to do? Getting them information and effective advocacy. So they can understand and they can go into these processes in an autonomous way where their voice will be heard. That's one of the things. I come from a long advocacy background, a long-standing advocacy background. And to me, survivor autonomy and voice in the process is really key to safety. And so we try to build that in what we do. But it's also, if a person chooses to get some help from the court or from others, how they get that information in an effective way to the court and to others. And so that's getting information to the system. Next, if we're talking about an order of protection, in issuing an order that's clear and enforceable. And I'm going to go through some of this in a little bit more detail. That's specific, that has specific instructions on what to do with your weapon, and maybe has some videos or other means of explaining to respondents or defendants in criminal cases what they need to do, so that no one can say that it was ignorance that caused them not to do what they needed to do. We want to set them up for success. Service of process, service of that ex parte order, and potentially the final order, is a key stage that is underutilized in terms of getting information about firearms access and, of course, getting the guns. So I'll spend a little bit of time talking about some strategies around service that may be helpful to you all to think about in Connecticut. Orders out there, orders been served. It's now up to the respondent, the prohibited person, to comply with this order. What does that look like? And how do we make sure that we're not operating under an honor system where those who want to comply will comply and those who don't face no consequences for their action and continue to pose danger? So I'll talk about some of the ideas there as well. If the person continues to violate, what do we do? How do we address violations? And importantly, how do we stop purchases of new firearms? And how do we address issues that are raised around the Fifth Amendment, the right against self-incrimination, if we're asking people to say whether they have guns or not? So I'll have a little bit to say about that as well. And then finally, at the end of this process, an order expires. The person may be eligible to get their gun back. What does that look like? How is that done safely? So I'm going to go through these in a little bit more detail, each step that I just talked about, to give you some ideas of what's out there in terms of practices. And before I do that, though, I just want to make sure there's no one who has a question they want to ask or an observation they want to make at this stage in the process. So I'll hold for a second.
We do have one question. Mark Pelka.
Thank you so much for your presentation. We appreciate it. I recognize how hard it is to be remote and delivering to the room, not being able to see us all, but we're all following very closely. My name is Mark, and I was wondering, regarding follow-through of a protective order involving the surrender of firearms, do you see best practices in states over what that follow-through consists of regarding the various stakeholders, you know, from the courts to law enforcement and so on?
Yes, that's an excellent question. I think it's really kind of at the heart of a lot of what you want to talk about. So let me go right to that, and I can come back and talk about some of these other steps in just a moment. So thank you for that question.
Thank you.
And we kind of consider that, you know, we generally consider it monitoring compliance with orders. And we use that language in part because we're not necessarily trying to arrest people. or charge them with criminal possession. It may come to that. We view this as setting people up for successful compliance with these orders to surrender. And again, to have it not be an honor system. And so this slide kind of walks you through what some of those ideas are. And so let me talk about them briefly. And if anything resonates for you or you have any questions, please let me know. So it all starts, earlier in the process with information and the court issuing a very specific order to surrender, if possible, as to what guns need to be surrendered. That can be a really effective part of this monitoring compliance piece. So the court has a role at that stage. In addition, as I mentioned, in surface of the order, officers asking about, explaining explaining the order, the terms of the order, including that surrender requirement, whether that has to be sold within 24 hours or it has to be given to law enforcement, what that means and how to do it as part of services process. And to say, look, if you give me your guns now, it's going to save you a step. We'll take care of them. You'll have an opportunity to get before the judge again, of course, on your final hearing. The judge may dismiss the order and you'll get your guns back at that stage if you're not otherwise disqualified. But by doing it now, you're kind of making the process easier on yourself. And that's an approach, sometimes we call it the warm approach, because it was developed by these officers in California. Their initials were WARM, but it also kind of describes this being a kind of a knock and talk and a conversational approach. They actually use plainclothes serving officers and unmarked vehicles to keep the temperature down. That's part of setting people up for success as well. But then once it's up to the person, if they haven't turned in their guns, they need to turn in their guns. How do you monitor compliance? Here are some of the ideas that we have seen to be effective around the country. And I have to say that a place that is really at the forefront of all this is King County, Seattle, Washington. They have a lot of practices that are worth looking at and thinking about. I don't know if any of you have been exposed to their work. I can connect you with folks from their firearms enforcement unit within the prosecutor's office that works with law enforcement, that works with the courts, to help you understand what a kind of a collaborative process, as you mentioned, Mark, around all the disciplines being involved, what that can look like. But one is to use, and I know you have a form along these lines, an affidavit or a declaration as to what's going on with the person's firearms. So they have some skin in the game. They have to fill a form out with the court around, do they have guns? Have they turned in their guns? What's the status? That's the basis for some potential follow-up. In some instances, in addition to that, or instead of that, folks use receipts from law enforcement agencies when guns are turned in. I don't know what you're doing in Connecticut. You may already do some of this stuff, but something that the respondent can turn into the court to show that compliance has been, that they've complied, that the guns have been turned in. One of the really key pieces to making this work that we've learned over the years in places that are doing it well is to devote some resources. And it is a resource. It takes a person, it takes money, but to have a court-based compliance officer or case manager whose job is, among other things, to follow up on what's happening when orders go out to surrender weapons. They're the person that these receipts or the affidavits can come into and get to the judge. They're the ones who can call on law enforcement if someone hasn't done what they were supposed to do. They're the ones who can set the compliance calendar and then bring information to that hearing about what's happening around firearms. By the way, these folks also can help with abusive partner intervention programming or BIP programming, whether people are complying with BIPs. They can help with all kinds of other things that people have to comply with, sometimes financial stuff and things like that. But on the firearm side, having someone with that role has really proven instrumental in the places that use a person. It doesn't have to be court-based. It doesn't have to be a court employee. We've seen it done with prosecutor's office. We've seen law enforcement agencies take on this role to some degree, but having a court person do this is really, really an excellent way to kind of choreograph all this and to identify when people aren't doing what they're supposed to do. The non-court monitoring is really about a law enforcement investigator or someone. So for instance, in Portland, Oregon, Multnomah County, Oregon, the way they have their system set up is the court faxes to the law enforcement agency, probably emails now to the law enforcement agency, all the orders that include firearm surrender. An officer then is responsible for making sure that the guns are turned in. If the guns aren't turned in, what they'll do is get with the prosecutors at the prosecuting attorney's office in Multnomah County, who will make a decision as to whether to go to court and do something about it. And so it's a very coordinated approach. The court is given the obligation of kind of figuring out what's going on and doing any investigation to the law enforcement agency, which then follows through. And it is governed by a memorandum of understanding that talks about everyone's roles. And we can share that with you and what that approach looks like as well. So there are different ways, of course, to kind of to peel this onion, to do this in an effective way, but they all involve kind of centralizing this idea that someone is responsible. Someone is responsible for making sure that where declarations or affidavits need to be filed, that they come into the court, and that there's follow-up. There's also monitoring by compliance review hearings. And this is something that we work on with many, we've been working on with an increasing number of courts around the country, in part because we have judges who have become real evangelists on this issue. They use compliance review hearings and they are big fans. And basically you set for a hearing upon issuance of an order, a compliance review hearing where the defendant has to come in. There's notice to the protected person. That person can or not, it's discretionary whether they come in or not. And at that hearing, the person's told, we will address whether you've done what you need to do under the order, including firearms. And there's a compliance docket in some cases. There is some judges just do it on their own and they set compliance hearings at the beginning of their schedule, beginning of their docket. And they do it purposely because they want everyone in the courtroom to see what happens at a compliance review hearing, showing that the court cares about these orders and that they're followed. And for folks who comply, it's a very pleasant experience. And for those who don't, obviously there's going to be follow-up and everyone sees that the court is paying attention to what's happening. So this is a complicated topic. It requires there needs to be some judicial buy-in. There needs to be room on the docket. Although the judges that we work with will tell you that they find that the efficiency of their caseloads is increased by bringing people in, or at least the threat of bringing people in before them. And so this is something we can share. Forms, processes, and most importantly, probably judicial officers who are doing it and doing it well, who can talk to you all, or any of your judicial officers who want to talk about that. I see there's a hand.
Yeah, Darren, hey, listen, yeah, thank you. It's CJ Force here. Is this where the issue raises regarding, you talk about the Fifth Amendment and the self-incrimination, and how does that play out in this compliance review hearing?
Yeah, absolutely. And thank you for asking that. You know, I'll tell you something about the Fifth Amendment that's very interesting that I've seen over my 25 years of doing this, is that in some jurisdictions, communities, it's a huge issue, and in others, it's really a non-issue. So it really depends on a lot of factors. In terms of the strategies around addressing that, one strategy is to include in these affidavits, information submitted to the court, the opportunity to say, I'm not going to, I refuse to respond to this on Fifth Amendment grounds, and I'm not going to provide the court with this information. That is not great if you want the information. It's consistent with the Constitution. And in fact, as it has played out in some places that do that, it doesn't result in everyone checking that box. Some people do, and many don't. So it's not kind of a deal breaker around this. Another approach that has been effective in some communities, some courts, is to offer immunity, limited immunity, to tell the court, turn in the gun, tell the court you have the gun. The goal here is to get the guns out of the hands of people who can potentially cause great harm. The goal is not necessarily to prosecute them for their illegal possession of that firearm. And in those communities, there have been prosecutor offers of immunity. And in fact, it's been codified in California. In California, under their statutes, judicial officers have the authority to offer limited immunity to get this information as part of a firearms relinquishment process in domestic violence cases. And so that's kind of a brief answer. We can talk more about it. There's nuances to it. A lot of it depends on exactly what the issues that are raised look like or not. But I mean, we can't ignore the fact that a court is not in a position to force someone into a position that they're going to be incriminating themselves. They have that protection. In civil cases, of course, you can make negative inferences based on that, and there's some subtlety around that as well. But it can be a live issue, or it may not be a live issue depending on how things play out. The final piece, thank you very much for that question. I think it's a really important one. The final piece I'll mention around this monitoring compliance aspect of things is third-party transfers. And so you have a process in Connecticut, which I mentioned, where the guns have to initially go to law enforcement or to a licensed dealer. Many places don't have that, and the gun can go to a third party right away who's otherwise eligible. And so we talk about how to monitor or kind of regulate that process. It's true for you as well. If the person wants the gun, if the respondent wants the gun to go to his brother or her sister or whatever it looks like, that person's going to have to go get it from law enforcement, right? And so typically in regulating the third-party transfer, there are a couple of important things. We want to have a process in which the person who's getting the gun recognizes that they cannot allow the person who's prohibited access to that firearm. It's actually a violation if you knowingly do so under federal law, maybe under Connecticut law as well. There's a law that covers that specifically under the Federal Gun Control Act. In addition to that knowledge, we want them to be eligible themselves. And so they should have a background check done, and they should not get a gun unless they themselves are eligible. And so those are the two kind of cornerstones or key aspects of a third-party transfer process. We've worked with courts that have required that third party to come before the judge and answer some questions before they get the gun. Because we know that giving the gun to your hunting partner or whatever it is lawyers will call it constructive possession. Real people will call it they got access to that gun, right? So, so that's something we want to be thinking about as well. I'll just share briefly a couple of things, forms here, and then I'll turn it back, Mark, if you have any follow-up or if there are any other questions around this compliance monitoring piece. One is the state of Wisconsin. So what Wisconsin did was interesting, and I'd like to share it with you all because it may be relevant to your work in Connecticut as well. They started with a couple of counties, a small number of counties started to do firearms surrender compliance processes along the lines of what I've talked about. They kind of tested it out. They then had a researcher from the university in Wisconsin come in and look at the impact in terms of guns being turned in terms of people feeling safe, et cetera, et cetera. And it had a statistically significant impact, and there was buy-in. And so the legislature in Wisconsin codified the process, and the courts developed forms to codify the process. And that's what's being used in Wisconsin now. Now, in the interest of full disclosure and honesty here, I work with people in Wisconsin a lot. It's not being implemented uniformly and well around the state. And now they're starting to come back and say, what can we do to make sure that this process we have that's really good on paper is actually happening in practice? And that's in some ways the position you all are in as well. But this idea of piloting something in a smaller number of jurisdictions, choose a rural part of Connecticut, you can choose one of your cities, suburban area, court, whatever that looks like, and try some of these practices. Get a compliance manager in place, a compliance officer in place, whatever that looks like, and learn from it, and then think about bringing that statewide. So that's what Wisconsin did. It resulted in this process, including these forms where when a judicial officer issues an order to surrender, they basically set a hearing, a firearm surrender hearing. If the person turns in their gun, it's canceled. That hearing doesn't happen. If the person doesn't turn in the guns, it goes forward, and there's questions that are asked. And part of that, another thing I wanted to point out to you in terms of forms, because as we know, forms can really make the difference in terms of practice. Wisconsin is one of a growing number of states that have included in some of their domestic violence protection order forms specific space to list specific weapons and where they may be in their serial numbers and things like that. Again, specificity of orders allows for easier enforcement down the road and for questions down the road about where those guns are. And so that's an example. Wisconsin has included that in their surrender instructions. And I'll just show one more. Actually, I'll have to show it later, but well, let me show it now. Skip around a little. It was previous. We worked with Vermont in one of our longer term projects to change their affidavit, their petition. They have a petition and affidavit for a protection order to include this language so that if a survivor seeking a protection order wants to inform the court that there are firearms present and they're concerned about them and where they are, and provide some more information about the use or threatened use of a firearm as part of their petition, they can now do so. Previously, the petition didn't have this information. And in fact, that box I'm showing you here with the type and location of firearms was then put into their orders. The court orders now, the judge can transfer that information so the serving officer knows, and so there can be follow-up around those particular firearms. So, so this is a practice that we promote, and I can tell you in Vermont, I know of a couple instances where this has resulted in what we think is increased safety. In one instance, in which the survivor filled this out and talked about a number of firearms that were in a safe within the home, and that he had previously threatened use, and she was concerned. Law enforcement went to get the guns; they were in the safe. Person refused, of course, to open the safe, whatever. They used this affidavit as a basis to get a search warrant. What was alleged in the affidavit was found by the judge to be sufficient to issue a search warrant, and the officers actually had to take the whole safe and to get the guns. And so that probably wouldn't have happened without this information explicitly on the petition and provided to the court in this way. And so we're big proponents of, again, victim autonomy is something that is always central in our thinking. So it's not, requiring people to do this, but to the extent that they want to tell the court because they're hoping the court will do something, and then obviously officers and others down the road, they can provide this information to the court. And so it can be the basis for further action. All right, so that is a long-winded response to your question, Mark. And I'm wondering if there are any follow-up questions or anything around this kind of the compliance review piece that you want to discuss, or if is there anything else particular, because I can just jump to particular parts of the presentation that are relevant to your concerns rather than just marching through the whole thing.
I don't know that there's any questions. So if you wanted to go back to where you were, I think we can do that. And then we can always jump around if folks have questions throughout the process. Mark, do you have another question?
I just was wondering,
Yeah.
any input from the subcommittee, any kind of areas of priority that we could ask to drill into? For example, it was helpful to hear the examples of monitoring compliance, addressing violations, return process. And I'm just trying to figure out if any of those fall into the orbit of what the subcommittee is currently reviewing, or if this is more kind of future orienting.
This is Andrea O'Connor. I am on the subcommittee. One thing that we talked about, and from my perspective as working with the victims, the biggest thing for us is monitoring the compliance, because at arraignment, they are ordered to turn over their guns if they weren't taken on the scene already. But the concern for us and the concern for the victims in the cases is that there is no follow-up to that to make sure that they actually did turn them over. So that was a big discussion. So I think this section is actually going to be really helpful because with this idea is that there is some sort of follow-up. And I think that is something that would be very helpful for the victims of these cases, is the confirmation that these guns were actually taken.
And this is something that we discussed even before this whole advisory board was organized. Members of CCADV, judicial, and maybe even a few law enforcement officers met with Judge Gold to see if we could sort of create a process to ensure compliance. And so it's actually good to hear and to see what other states are doing. So maybe it's time that we circle back to Judge Gold or get together and sort of discuss ways that we can implement the surrender or change the language on the compliance forms just to ensure that those who are subject to an order are complying.
I know we have Senator Flexer on Zoom, and then I'll get to Karen in a second. Yep.
Thank you. Thank you for this presentation, Darren. I just had a question. You had offered to help us drill down and look at, how to implement some best practices. And when you made that offer, you said you could either do it, on a smaller local level or a smaller jurisdiction or statewide. And I just wondered, in your opinion, is that work better done small first and then statewide, or is it better to attempt to do it statewide?
Great question. Thank you. And I am a big proponent of this kind of piloting things and trying to do it, as I mentioned, in places that are kind of characteristic of different parts of the state, and then learning those lessons and then bringing that information forward in terms of a statewide response, like they did in Wisconsin, like we've been doing in a couple of other places as well. It's kind of hard to set. I mean, Connecticut, I think you have something of a track record of working statewide and then having folks implement locally. So, I mean, that's obviously possible, but I think ideally you can test things out on the ground and learn from it, and then build on that and ultimately bring it so that it's applicable to folks throughout the state.
Yeah, that's interesting to hear because, as you said, we have done a lot of things statewide. And when I think about some of the things in this arena that we have piloted on a local level, it has then taken us as long as more than a decade to implement them statewide, even longer sometimes. So that's my only hesitation about potentially looking at the smaller jurisdiction, is that we might have some success, but then we lose the momentum to apply it across the state. So thank you for that feedback.
Yeah, I mean, I'm not totally surprised to hear that too, and it really depends on the circumstances. And I think that it's also possible to do them in parallel, and to be to be thinking statewide and implementing. I mean, I don't know what this looks like, whether it looks like new code language or it looks like I know you have folks from the statewide law enforcement training grant, to get it into training and then build and while you're also working with some local communities to try to do some of this work. So I think it could be done in parallel. And I'd be happy to have further conversations about, the specifics in Connecticut and what it looks like. States are so different in terms of the kind of the state level influence on localities. And if the statewide, if statewide work can have a real influence and impact on what people are doing locally, then that could be a better strategy. But I work with a lot of places where that's not the case. And you really kind of have to do it on the ground before you get traction statewide.
Right. Thank you. Thank you very much. And thank you, Chair Scanlon.
Thank you. Karen, I know had a question or a comment.
Yes, thank you, Dennis, for especially focusing on this compliance, and thank you, Mark, for asking the question. I was actually going to comment to Andrea's comment, and there is a compliance system in place with law enforcement. The problem is it takes a long time to get to that, but she brought up a really good point. Is I don't know that from my previous life, there was no requirement to let the victim know what happened. So I just wanted to, point to that group that I'm sure Andrea is bringing that to the table, but we could do better there for sure.
Yeah, and I know that was brought up in the subcommittee at our last meeting, the fact that there is no way to get that information back to the victim consistently. Mark.
Let me ask one more question too, please, about the growing attention nationally to emergency risk protection orders, especially with the federal funding made available to states to implement them. Connecticut is the first state to have such a law in the books, and it allows the ability for a warrant to be issued for the surrender of those firearms. And I think that separate process raises just questions about the implementation. It's quite a resource intensive response, and it's meant to prioritize the kind of most emergency, highest risk cases. Is there anything you found from the growing attention nationally to risk protection orders and how lessons learned from that implementation of those could give clarity or guidance to firearm surrender and protective orders?
Yeah, thanks for asking that question. And actually, so a couple of things around the so-called ERPOs, or firearms risk protection orders. One is, and I just want to say this, every time those are raised in the context of domestic violence, and I know that's not how you're raising it for lessons learned from that process that can be applied to this process, but just a caution that those, have a very, as you said, they have a very particular purpose and effect, and they are not, they don't provide the holistic relief that's available in domestic violence protection orders. And so they shouldn't necessarily be considered alternatives to domestic violence protection orders. And once people start kind of talking about both, I've seen this in my own state in Maryland, where judges have told survivors to go get an ERPO instead of a DVPO because it's more likely to result in the guns being taken away. And that can be problematic for a lot of reasons. So that's just a brief preamble. Those processes, and we work very closely with the Johns Hopkins University group that focuses on ERPOs. And in fact, the grant program, the federal money that you've just talked about, Mark, the National Council is one of the 3 technical assistance providers for that particular program for the courts. Johns Hopkins University is the ERPO technical assistance provider. So we're working really closely with them and have been having conversations about lessons learned from both processes that can inform the other. And one of the interesting things is from those conversations is that the compliance piece, the follow-up piece, not everywhere, but in many places kind of lags behind even where it is in domestic violence in some ways. But at the same time, because those are and I can't remember your law, but most of those I venture to say nationally are law enforcement initiated or prosecutor initiated. There's more skin in the game for law enforcement. And so where it's working, law enforcement takes them more seriously and will do some follow-up in a way that they may not in domestic violence protection orders. So that's kind of skin in the game because they were behind the application for the order, is part of the reason that in some places, they're more effective. But in terms of the compliance piece, it's kind of similar. We're finding that you need to have someone in the court, ideally, who's kind of paying attention, making sure that where there are affidavits or declarations that have to come back to the court showing compliance, that's being monitored and there's follow-up. Some judges are doing review hearings in ERPO cases, many are not. So we're kind of, at this point, I would say, I don't know of any specific lessons to draw from that, but as we see more of the greater implementation, and as Johns Hopkins and some of their research partners are looking at implementation of ERPOs, we're going to learn more over the next year or so, especially because there's a lot more focus on that. So unfortunately, I don't have any specific answers. I do, if you're interested in this and you have not made contact with the Johns Hopkins folks, let me know. I will connect you directly with the people who are overseeing that work, and I'm sure they'd be very happy to talk to you. And one of them has a history of working on domestic violence issues, and specifically protection orders.
That's great. All right. And I think we have one other on Zoom. Jerry Wild has her hand up.
Sorry. Good afternoon, everyone. And thank you very much, Darren. I appreciate your being here with us today. I wanted to add on to Karen and Andrea had mentioned about the victim notification, because in Connecticut, actually, victims don't have a right to know whether someone's in compliance. And I know you and I spoke about that. So I didn't know if you could, Darren, mention as far as what other states might be doing around victim notification when somebody is subject to order of protection and are not eligible to possess. Are victims being able to be notified in other states?
Yeah, thank you. And I was gonna get to that because we talked about it earlier and it came up a couple of times here. So absolutely. And I did some after our conversation, Jerry. I called around and spoke to some folks I work with in states where I know they have systems that seem to be working pretty well. And generally speaking, you're not alone in not having a right to that information. The way that it typically works is some states do have VINE, the protection order part of VINE, the victim notification network, and have included, I think one has included firearms what the result of service of process on the Vine piece where it can be looked up. There are a couple of states where I've been told, I haven't seen it yet. I've been told where the accessible, publicly accessible information includes whether an order has been served or not. And that's as far as it goes. So typically, official processes, technology, all those kinds of things are not how victims are being notified about what happened at surface of process. And I have to say, sadly, that most places are kind of in the same position as you. Many survivors don't know what happens. But where they do, it is the result of collaboration. It's a result of law enforcement, victim advocacy, collaboration. Some instances, someone told me that, you know, when the officer gives a survivor their card, they say, look, I can tell you what's happening in this case moving forward. Please reach out. So they take it upon themselves to get that information. But typically it is through victim advocates who are working in a coordinated and collaborative way with law enforcement to get the information, or they're going to the court to get the information on behalf of survivors. So it's not an automatic, in no place do I know of it being an automatic process. It's more about relationships and communication. And so one of the things when I talk about service of process, we always have victim notification as one of the hallmarks of an effective service. It's part of service. Part of service should be letting the survivor know, was the order served? If it was served, what happened? Of course, that's critical for safety planning, not only about guns. What was the person's response? What did they say or do? What did that look like, right? All of that stuff. And to the extent that is conveyed, it's conveyed, I'd say in the vast majority of cases that I know of, when officers talk to advocates who are working with survivors. And places that are implementing co-response models, where officers and advocates either go to the scene together or there's a quick follow-up by advocacy and there's that coordinated work. There's lots of information about service of process being offered in a subsequent protection order. And where that's lacking, you get less of it. I know it's not a very satisfying answer, but that reflects, you know, obviously I can't talk to everyone and we didn't do a big survey, but talking to some key folks and just based on my experience over the years, that's where we are on the national landscape.
Thank you. And Megan, I'm sorry, I'm going to continue. And I know Captain Maynard has his hand up, but to it, and Darren, you and I spoke about this. I mean, again, Connecticut has done some great work around firearms, from law enforcement with dispatchers asking about firearms, law enforcement seizing, ability to seize on scene, law enforcement screening through LAP, even having the firearm ammunition compliance statement available for offenders of domestic violence to sign. Family court, the applications include a location on the application for a victim to indicate if there are firearms. And in the criminal court, the family violence advocates and family relations work together around a domestic violence screening tool that also asks questions regarding firearms. And I think for Connecticut, and again, with this council specifically, you know, we know that there's gaps so that offenders, respondents we know are not complying, not all are complying in that 24-hour notice. And the criminal and family courts don't necessarily inquire about compliance. And I think that for CCAV has been a challenge, that we have these great orders, we have all these processes in place, but we're not even asking about it to follow up on whether those are enforced. And then, you know, I mentioned about the victim's right to be notified. But again, there's not a safe, uniform protocol or process to address the monitoring and compliance here. And I'm hoping that with your input today and the work of this council, that we'll be able to identify something universal. So it won't matter whether it's an issue being addressed in the Stamford southern part of the state or the northern part of the state. So I just want to thank you again, because we do have some work, but we've done some great work as well. So.
And I just very quick response. I said it before. As I said, we have kind of judicial evangelists around how that can be done, how it can be done efficiently and without, you know, a huge time burden on dockets and things like that, and in a way that's effective. So to the extent that anyone in the judiciary is interested in at least having that conversation, we can certainly set it up. We're very happy to set it up. We also have some guidance around and some recorded webinars on compliance monitoring. So I'll be sure, Jerry, to get all that to you, and you can share it with the committees and think about it, because it's something that we've been working on for many years, because we see exactly the need you're talking about nationally.
Thank you.
Thank you. And Captain Maynard, I think, has his hand up.
I did. Thank you. I actually just wanted to give awareness to the council. So Spencer Cantrell and Lisa Geller from Johns Hopkins University did coordinate a site visit to Connecticut, which is scheduled right now for July 16th to 18th, to specifically talk about ERPOs, so the extreme risk protection orders. They did also reach out and coordinate through Commissioner Higgins' office for something with Post and the Connecticut State Police. But I just want to throw that out there to the council. I don't know what their full itinerary looks like, but we do actually have a site visit scheduled within the next month.
Okay, that's great. We can follow up appropriately. And I think, Mark, did you have a question or comment?
I really enjoyed the discussion about providing victims information, and VINE was mentioned, the automated victim notification system that victims here in Connecticut may opt into. And I can take a closer look. I wanted to just share my current understanding of which events include an automated notification. And there are events for protective orders, restraining orders, and civil protection orders, issuance, modification, and termination. So to the extent there are further discussions about how that notification fits into the array of ways we want information to reach victims for planning safety purposes, I wanted to mention that, while acknowledging VINE is an important tool. It's an automated notification. It's information delivered to victim via text, app, email, phone. It's a critical foundation, but it's the essential work that accompanies that, provided by a human, by a victim, family violence victim advocate, victim services advocate, others advocates across. Thank you, Madam Chair.
Any other questions or comments? All right, hearing none. Darren, we're going to have you at every meeting. This has been the most engaging, productive meeting we've had so far. But getting back to your presentation, just wanted to give you the rest of the time. We have about 20 minutes left. And if folks are able to stay over, we can certainly stay over, but I know I want to try to keep to time. So
I have something right at 2, so I won't be able to, but I'm happy again. I'm giving you an overview of a whole bunch of stuff. I'll make sure, I know that Jerry has a copy of the slides. Feel free to distribute it to everyone. And I believe my contact information is on the last slide, and if it's not, I'll give it to you before we go. Again, we're very happy to follow up with whatever information you'd like. So I'm just going to touch on a few key points that we have found to be kind of important in this work. And I mentioned earlier on this information gathering piece, and this is just some suggestions or some things to think about around that piece. And we've talked about this right here. I give a bunch of examples about this, but this is a different kind of form. I don't know if it's in use here. It's this firearms information sheet. This is an example from Columbus, Ohio, with whom we worked for a while, that adapted it from King County. And the idea here is it's used in different ways. This one is typically used in a conversation between an advocate and a survivor who is going to be applying for a protection order to talk about guns. And the idea here is, if the person is wanting to seek relief from the court around firearms, to have a conversation that talks about all these different things, right? About all the aspects of what the guns are, where they are, how they've been used, et cetera, et cetera. Do you know whether they're legal possessors of the gun, et cetera. And part of the idea here is that this information in Columbus and in King County can be attached to the petition for a protection order. So the court has it, of course, the respondent will see it too then, but it can be attached as additional information for the court. Alternatively, if the survivor doesn't want that, it can go to law enforcement, to serving officers. So as part of their, hopefully, packet of information that they have, when they go out to someone to serve an ex parte order, where there's firearms involved, where you know that that's an issue, they can have this information with them. that can be helpful in terms of safety and, of course, firearms access by this person. So it's a way to convey some information about the survivor's experience around guns to the court, potentially, definitely to law enforcement. And there's various versions of this form. They typically have something like this, where a survivor can potentially identify a firearm by the type. If they don't know exactly what it is, they can identify it through a picture. And we have several examples of these kinds of forms. So I wanted to share that. That's something that we're seeing more and more places use and have found to be effective. The BWJP SAFE tool, BWJP is the Battered Women's Justice Project. They're a national organization that actually hosts 2 firearm-specific projects. And but prior to all that, we worked with them to develop this SAFE tool, which is essentially an advocate's guide to safety planning and having conversations around firearms with survivors. And so there are, it guides conversations, a whole bunch of questions to ask. And again, focused on the fact that the person may or may not want the court to know, may not want the system to be involved in the firearms, but to have that conversation. And again, it uses pictures to help you, to help with those conversations. So the SAFE tool is available from BWJP for those of you who do advocacy with survivors. It can be a helpful guide in doing that work. I'm going to skip around just a little bit based on what I've been hearing areas of interest are. I already said a little bit about service of process. I just want to emphasize it for another minute because, again, we have found it to be a key step in the process. In a growing number of jurisdictions, a lot can be done around service. And the things that I wanted to mention that I didn't say before were, of course, the agency having a protocol for service of process can be really helpful. And again, King County and a neighboring county in Washington State are kind of at the forefront. They developed a firearm-specific law enforcement protocol for service of process. What officers can do, should ask, can say, steps they can take around trying to get firearms if there's one in the case and an order that requires surrender of weapons is present. Something, of course, that you can train officers on, that you can hold officers accountable to, can be really helpful. So to the extent, I think you have a statewide protocol around domestic violence in Connecticut for officers, to the extent that you can incorporate firearm-specific language beyond what you may already have, and specifically around service and authority to search for weapons and the questions you can ask and things like that, that can be enormously helpful. Having someone in the serving agency, whether it's an advocate who works there or an officer, talk to the survivor before service of process is a practice that actually has been used in my county, Montgomery County, Maryland, for many years, and in other places as well, where an officer or an advocate will sit down and they'll use that form I just talked about. They'll ask questions about guns, but other risk factors as well, so that serving officers have that information when they go to serve the officer, the order, and they can be safe and they can be effective in that service. Related to that is the development of service packets, ensuring that officers, and again, I'm not speaking to practice in Connecticut, but I've worked with many places where the status quo is patrol officers pick up these orders and kind of serve them when they can. They're not prioritized. There's no special protocol. There's no special approach or strategy, including if there's firearms. There can be such prioritization and strategies around protection orders and around guns specifically. You may already have that. But part of what we have learned works well is to develop service packets where someone in the serving agency looks at the criminal history, looks at any information they have about firearms access or use in the past, looks at other orders. If the person's under supervision, speaks with the parole, community supervision folks, gets as much information as possible to ensure safe and effective service of those orders, and the officers know what they're going into. And so something to think about as part of your protocol. What steps are you taking to understand what risks this person may present, both to the officer and to the survivor, and to go about that job effectively? I mentioned the warm approach, the knock and talk, the conversational approach. I talked a little bit about third-party issues upon service of process. In Connecticut, the gun's got to go to law enforcement or an FFL. What do you do if the person says, well, I want to sell it to a dealer? I want to sell it back to the dealer I bought it from or whatever. What does that look like? What do officers have a role in making sure that happens in the next 24 hours? Just conversations about that piece, I think, could be helpful for you all to think about. I don't know if it's a big issue for you, but it's just something to be thinking about. And as I mentioned earlier, the victim notification piece is always part of our service of process conversation, and we discussed that. We also discussed compliance monitoring. And what I guess I want to do, because we already talked about some of this stuff is, and I talked about returning guns to some degree, but, and I know you have a bit of a process already in Connecticut, but the bottom line for returning guns when orders expire is to try to make sure to notify the victim that this is happening so that they can safety plan. I work with judges in DeKalb County, which is partially in and partially outside of Atlanta, Georgia, where they hold compliance review hearings. And in fact, if your judges want to talk to a judge, I'm going to bring in that judge because she's amazing. But they also hold full-blown hearings around return of firearms and ask questions. And in some instances, the victim comes and explains reasons why the person shouldn't get their gun back if they want to. And that's resulted in guns not going back to folks, especially where, of course, the background checks shows that the person is ineligible. And there should always be, and I'm sure this is true of Connecticut, law enforcement agencies shouldn't be giving guns to folks unless they undergo the background check and make sure that there's no federal or state prohibitor in place. So a return process is an important thing to think about. So I only have about 10 minutes left, and I do want to talk about the criminal side. And we've mentioned the criminal side, and I know that you talked about, at least one of you talked about no kind of follow-up on the criminal. If there's arraignment, guns are ordered to be surrendered, there's no follow-up. So we have some strategies around criminal processes that include thinking about all that stuff. I'll just spend some of the remaining time talking about them. If anything resonates with you, I can show you examples and we can talk further. We can do some follow-up. But just to give you some ideas, a sense of what's out there. Jerry mentioned 911 and questions being asked. Wonderful, best practice. We are trying to promote that elsewhere as well. But again, law enforcement protocols. So this is starting at this, at the 911 call and the initial response at the scene. You have a law that allows officers to take the firearms under certain circumstances. Are they trained? Do they understand the contingencies if something different is going on? Do they understand their ability to ask for guns for safekeeping? It's generally accepted that you can ask for voluntary relinquishment of a firearm temporarily for safekeeping purposes. Are they doing that? A protocol around law enforcement response and firearms at the scene can be instrumental in helping you think about what that could look like, and then obviously training officers and holding them accountable to doing all this stuff. So we think it's really important to have protocols in place around this stuff. You have, and I'm just going to show it real quickly. You have a family violence offense report. It includes information about firearms. I know the officers here know that. It has information up, I can't really highlight it, but weapon codes, number of weapons used by type. So you have space to talk about guns. Are officers using the remarks section? Are they taking advantage of this offense report to talk about firearms, which of course could be important moving on in the criminal case. It can be important information to be shared with folks. So just be thinking about, should this report be amended to include more of that information, or should officers be trained to make sure that if firearms are an issue, even if it's just access to a gun, to note that the person has guns, right? Even if it's not used in the offense, that can be important information as well. So to be thinking about that part of the process also. This is a document. I know if you have your phone, you can pull it up, and I'm happy to share it with you, of course. We gathered law enforcement protocols around firearms and domestic violence cases from around the country. I think we collected somewhere around 20 of them. And we have kind of come up with what we think are important components of those from start to finish in this document. So for each of the types of elements of a law enforcement protocol, we think is important, we have examples. And so it's a PDF document, and here where it says Snohomish, King County, you click there, it gets you to the Snohomish County, King County, Washington protocol, and shows you the language where they do this particular thing. So this is for those of you who are thinking about protocols, this is a really good tool to use that we developed a few years ago, where we've really done a lot of the research around what's happening around the country in the protocol arena and gathered it for you. LAP's already been mentioned. One of the things I'll mention myself around LAP, and this is, many of you have probably seen this, 2021, weapon use, threats to kill, gun access are relatively prominent in the positive responses for risk factors under your state implementation of LAP. You all are state-of-the-art and had state-of-the-art national experts as part of your LAP. My question is, how is the LAP information used? Obviously, LAP is designed so that you can connect someone with an advocate on the scene. They can do follow-up, they can do safety planning, et cetera, et cetera. When an officer gets this information, what's done with it? Or when the advocate has a conversation with the survivor around the firearms access, what does that look like? That safe tool I mentioned earlier can be used for those conversations, but just for you all, you advocacy organizations who I know are here, have you trained all your folks to have particular conversations that are going to be helpful around firearms, if firearms is positive in a LAP lethality screen implementation? Again, just throwing out some ideas. On the pretrial, the arraignment phase that someone mentioned, we have ideas around different folks' roles in all of that. And certainly, to the extent you have probation, court services, someone who's got a responsibility for what happens at arraignment and after arraignment, whether they're making recommendations about conditions of release or bond bail, whatever that looks like. Again, I don't know your Connecticut process, but they can play an important role in terms of firearms and in terms of monitoring and things like that. And we have some examples and suggestions for what that can look like as well. I mentioned lethality assessment. Arizona has a risk or lethality assessment that's used, and they use something called appraise. That information is supposed to be given to the court in terms of a bail determination. And they thought it was so important to do, they codified it in Arizona. Again, something to think about. We know that most criminal cases play out. And we know that in some instances that it can include deferred adjudication, right? Continued court supervision to the extent that if a person reoffends, the charges will be reinstated, et cetera, et cetera. I don't know if you all have had conversations around this, but think about, if firearms are an issue, think about what that looks like, because the person may plea to an offense that doesn't render them unable to have a firearm, or a deferred adjudication is not a conviction that doesn't trigger a firearms prohibition. So what can be done about that? What should that look like? And we have suggestions for orders that, like, and this is an example in Indiana where there's a deferred prosecution, withholding prosecution, and there's an order that's issued to the court that includes a no firearms, deadly weapons, or ammunition as part of the terms of the withholding of prosecution. I don't know if you have that in Connecticut, but it's something to think about. So I'm gonna stop there. We have other examples. I'm gonna get you the slides. Again, if anything resonates for you on the criminal side, happy to have those conversations. Happy to connect you with folks who can be of assistance. So I just said a lot of stuff in a lot of areas. A lot of it you've already thought about and have been talking about. So I hope some of it landed and has been helpful. But really consider this an open invitation to reach out again. I'm looking at my last slide to see if I have my contact information, and I do. So let me just quickly share my slide again. I can put it in chat too, but I'm not sure that everyone's going to be able to see chat. So let's see.
Yeah, and we'll send out the slides, Darren, too, so everybody will have that information.
Thank you. But my email's here, dmitchell@ncjfcj.org. As you can see, we're supported by the Office on Violence Against Women to do this work. Of course, nothing that I said reflects their opinions or views, reflects mine. But our organization is funded to help you with this work in whatever way we can. And thank you so much for all the work that you do. And we have some folks who I know have heavy responsibilities in this area. So I appreciate everything you're doing in your own job, on this committee, and for taking the last hour and a half or so to listen to me.
Yeah, we definitely appreciate you coming and presenting. Certainly very grateful. It gives us a really good roadmap, I think, for some of the work that we have to do over the next several months for our recommendations. I know we have 2 minutes left of Darren's time, so any questions, comments that folks wanted to get in before he has to hop off? Okay. CJ? No?
No?
Okay. All right. Thank you very much, Darren.
Thank you.
Thank you all. Take care.
Darren.
Bye.
Okay. All right. That was a lot of information. So we'll send out the slides. I really want to thank everybody for the really great discussion, great questions, engagement. So this will really set the tone for how we move forward with the committee, with the council, which is great. And then obviously some of these issues will be worked on through the different subcommittees. So any other last comments, questions regarding the presentation before I move to the next agenda item? Okay. Any other business that anyone wanted to bring before the council? Anybody on Zoom? No? Okay. All right. So the next item is just to set the final 2 dates of the year, which is pretty crazy that we're getting to that point. But so the full council will meet September 25th, same time, 12:30 to 2, and then December 4th. At that December 4th meeting, we will need to be reviewing a final draft of the recommendations that we want to then submit in the new year in January to the legislature. So if folks have not set their subcommittee dates, now would be the time to do that, to be able to work through some of the priority areas there. And then ideally, maybe we could have at the September meeting, maybe more of a working meeting to bring forth some of those draft recommendations and work through those, have really open, honest discussion about them, and then finalize that and bring the final to the December meeting. Any questions, comments, suggestions about that process? Mark?
Is a thought that the subcommittees, Madam Chair, will bring out draft recommendations in September for us to discuss, provide input, and then
Yeah.
subcommittees will reconvene and bring back a final.
Yes. Yep.
Thank
Yeah.
you.
So however your subcommittees want to meet from now until that September date of the full council, I'll leave that up to the subcommittees. But yes, that's the idea. All right. All right. And now just moving on to adjournment. I just need a motion to adjourn.
So moved.
Second.
Great. All in favor? All right. Thank